Good morning, everyone. My name is Jelena Gilliam Pace, and I am an associate at Scott Legal. Welcome. So we're going to spend some time today talking about moving from a non-immigrant visa to a green card. This is a very common topic of conversation, and there's a lot of questions that we receive about how to do so. So we'll be focusing on employment and business green card options, such as EB2 and EB5, and we'll discuss some options for entrepreneurs as well. Today, we're fortunate enough to have Dustin here. He has some experience in some of these categories. And so a few things before we get started. The firm is a full service immigration firm, but we focus on business visas, including green cards with a national interest waiver category. Um, we will continue this webinar series doing at least 2 webinars a month on different topics. At the end of this webinar, we'll send you a few things, the PowerPoint, a link where you can sign up to additional webinars, and a link to our YouTube channel where you can access several different webinars and information if you have some questions on different topics that we didn't cover today. If you have any questions, please place your questions in the Q&A chat box, and we'll be monitoring the questions to have a Q&A at the end of the session. And finally, the webinar is recorded and will be available through a follow-up email and on our YouTube channel. So without further delay, I'm going to pass it over to Dustin.
Great. Thank you, Jelena. And thank you all for taking the time to join us today to talk about the pathway from a non-immigrant visa to green card options. So to start, let's take a step back and talk generally about basically the green card system in the US, or how permanent residency in the US works. And the fundamental thing to keep in mind about the US immigration system is that, unlike some other countries, there is not a point-based system. So you do not get preferential treatment, for example, for speaking English, or for having created a business or created job opportunities in the US. The way that you apply for a green card in the US is by qualifying for the specific green card category. And there are 2 broad categories of green cards in the US. Those are family-based and employment-based green cards. And when I say green card, I am talking about permanent residency, as well as an immigrant visa. So I'm using the term broadly. But let's quickly look at those 2 buckets, family-based and employment-based. To qualify for a family-based green card, you're basically qualifying based on a family relationship you have. So that could be your marriage to someone, it could be your child, it could be your parent, or a sibling. When we're talking about employment-based green cards, that gets into more detail, and we will go through the examples you see on your screen, with the exception of EB4. But we'll talk about those in more detail. But those really are divided based on your education, your professional background, as well as whether you are an entrepreneur, and whether you're applying based on investment. So again, we'll talk about those and how they're split into those preference categories in later slides. For now, just keep in mind, family-based and employment-based are the 2 big buckets. So you've probably heard that applying for a green card in the US takes quite a while. Generally takes at least a year, start to finish. For some of these categories can take 7 years, 10 years, 15 years. And we'll talk about those, but there really is a wide range of timeframes we're talking about. And why is that? The fastest category is going to be immediate relatives. And basically what that means is I'm gonna actually tell you exactly who an immediate relative is. If you are a US citizen sponsoring your spouse, then the spouse is an immediate relative, as well as an unmarried child of a US citizen who's under 21 years old, or the parent of a US citizen, if the US citizen is 21 years old or older. So those individuals are able to apply for a family-based green card as an immediate relative. Why is that an expedited category? I shouldn't say expedited. The reason why it is relatively faster is that green cards are always available for immediate relatives. Basically, what the US Congress did was it said every year we are going to make available a certain number of green cards. And the top priority people who are going to get those we'll call first preference, and then there's second preference and third preference. So those are individuals who get the allocation of green cards every fiscal year. And each fiscal year, the government might run out of green cards. And that's why we have such long waits, is that you are then in line to get those green cards where the government is giving out more than are available, or I'm sorry, the government has more applicants for them than are available each year. Immediate relatives are outside of those preference categories. So for immediate relatives, green cards are always available. There is no limit to the number of green cards that can be issued. And so you're not going to be held up for years because a green card is not available, as could happen in the preference categories. So again, immediate relatives are U.S. citizen, spouses of U.S. citizens, children of U.S. citizens if the child is under 21 and unmarried, and parents of U.S. citizens if the U.S. citizen is 21 years old or older. So what are the family-sponsored categories? We will get into more details on this in the next slide, but uh, unmarried sons and daughters of U.S. citizens, if they are 21 or older, those are first preference family-based green card applicants. Second preference is going to be spouses and children of permanent residents. So keep in mind, permanent residents, you cannot sponsor someone as an immediate relative. Those relatives, whether a spouse, a child, are going to be placed in a preference category. So there may be a delay. Third category is married sons and daughters of U.S. citizens. So again, if they're 21 or over and married, or under 21 and married. And finally, the fourth category are brothers and sisters of adult U.S. citizens. Where can you find out what the timelines are for these? The answer is the Visa Bulletin. So every month, the US Department of State publishes what's called the Visa Bulletin. If you are at your computer, you can Google now Visa Bulletin, and you'll see that the most recent version, December's Visa Bulletin, was just released. And it is helpful if you are able to visit this on your computer because this information is presented in a table. And what you'll see on the table is rows titled F1, F2, F3, F4. Those are the preference categories that we just talked about. And those are in the column going down F1 through F4. And then along the top, you see certain nationalities. You see China, India, Mexico, Philippines, and then basically all other countries. These are the countries where you were born. So for a green card, it really does not matter where your passport was issued. What matters is where you were born. So if you were born in India and you are a naturalized citizen of Canada, unfortunately, you are going to be in the category for nationals of India. There is an exception for this that we're not going to get into right now, which is called cross-chargeability. If you are married to someone who is of a different nationality and also going through the process, you may be eligible to change your country of chargeability, meaning the country that the government considers you to have been born in for green card purposes, but schedule a consultation if that applies to you. It is a somewhat nuanced area. So what you're going to do to read this chart is you're first going to figure out what your preference category is. Are you applying based on a U.S. citizen brother or sister? Are you applying based on a U.S. citizen parent or child? And you're going to put yourself in the relevant category, and then you're going to scroll across to your country of birth. So let's just take a quick example. If you are a brother or sister of a U.S. citizen and you were born in Canada, you would be in the all chargeability areas except those listed. And right now, Green cards are available for those individuals if they filed their application in August of 2007. So quite a long time ago. You see how this can take a long time. If you were born in India, then right now they are considering applications filed in March of 2006. And if you were born in Mexico, 2001. So there is a 23-year delay for you brothers or sisters of US citizens if the brother or sister was born in Mexico. That's why this chart is really important. It does give you a sense of how long you're waiting. Now, these dates, like I said, this chart is released every month. And the reason is basically the government is keeping tabs on how many green cards it's issued. So these dates do change. They can go forward, but they can also go backwards in something called retrogression. So you do need, or your attorney needs to keep in mind how these dates are progressing forward or backward. But for the purposes of this presentation, this gives you a snapshot in terms of the difference in timing, how long it's likely to take for you to get a green card based on your preference category as well as your country of birth. So we will go ahead and move on to the next slide. I've already talked about this in the previous slide. The part that I did not talk about is the process. There are two main pathways to get a green card. And again, I am using the term green card broadly, basically to mean permanent residency. The two main processes are if you're in the US and if you're outside the US. If you're inside, let's start with outside the US. If you're outside the US, you are going to do something called consular processing. And that means you're going to apply for an immigrant visa at a consulate. You will basically you will submit an application to USCIS. USCIS will hopefully approve that application, and then the application is sent to a consulate, which will call you in for an interview. You'll go to your interview. If you're approved, you will be granted an immigrant visa. Usually that visa is valid for about 6 months. You will then enter the US, and once you've entered the US on your immigrant visa, you'll receive in the mail, usually a short time later, your physical green card. So that's the process if you're outside the US. It's called consular processing. The process if you're inside the US is called adjustment of status. Basically, you'll be in the US in whatever status you have. That could be a student status. It could be a temporary work visa like a TN or an E2. It could be even a visitor visa. And you will submit the application form to USCIS. The difference here is that you would submit as well a form I-485. So the form I-485 is basically the green card application. And then if you are approved, USCIS will essentially mail you your green card. So there is no requirement to go to a consulate in general, if you're going through the adjustment of status process. Consular processing is available if you're in the US. So if you're in the US, you do have both options. If you want to apply at a consulate, you can do that. And that may be strategically recommended or advantageous if, for example, you're in the US on a non-immigrant visa like a TN, and you don't want to have issues traveling on your TN with a pending green card application. Because keep in mind that most non-immigrant visas like the TN, like the B1, B2, you're not allowed to plan to adjust status. If you enter on a TN visa and you tell the border officer, I'm going to enter on a TN, but I plan to apply for a green card, you will be denied, because a TN requires that you have non-immigrant intent, meaning you plan to leave at the end of your status. So if you're worried about that being an issue, you can choose consular processing, so that if you're at the border and the officer says, I see that you filed a green card application, you can say, correct. However, I applied with consular processing, therefore I have to leave the US to get my green card. I am not going to adjust status. It doesn't automatically solve the problem, but it certainly does reduce the risk that you'll be denied entry. So consular processing is available whether you're inside or outside the US. Adjustment of status is only available if you're inside the US. Now, one quick note with adjustment of status. Adjustment of status can be hugely beneficial if you are eligible for a green card, meaning if you look at the visa bulletin and you see that there is a C in your category, in your box. C means current. What that means is in the table I was talking about before in the visa bulletin, what a C means is that green cards are available for that category. What that means is if you are adjusting status from within the US and you look at the visa bulletin and it says C, or if you're an immediate relative, so immediate relatives are always current, there are green cards always available, you can file at the same time that you file your I-485 application for a green card, you can file your application for work authorization and travel authorization. That's a huge benefit because once those are approved, you are able to work without restriction in the US and you're able to leave the US and travel back based on your travel permit. Those applications, a travel and work permit, do take about 6 to 9 months right now. That can change, but for that 6 to 9 month period, you do need to stay inside the US. If you leave, you abandon those applications. You also abandon your green card application. So keep that in mind. You do need to stay in the US while the travel permit is pending. But let's take an example. If you're applying, and we'll talk about the EB-5 in a few slides. Let's say you're applying for an EB-5, which is the investor green card. You've invested a lot of money. Right now, even though green cards are current on the EB-5, the government takes a long time to decide the application. So an EB-5 application could take 2 years or so for the government to approve, even though green cards are available for the category right now. So if you're inside the US or if you're outside the US, you don't want to have to wait 2 years for USCIS to decide that application. So if you're inside the US, let's say you're in the US on an E2 visa, you decide to apply for an EB-5. If you're current, which right now EB-5s are current for most, if not all of the categories, you can file the I-485 as well as the work and travel permit applications and be able to work without restriction in about 6 to 9 months after filing that application. So that can be a huge benefit if you're looking at a timeline in the alternative of 2 years or more. So let's now get into some of the specific employment-based green card categories. And I will start with the EB-1A. And in general, the way these preference categories work from EB-1 to EB-3 is EB-1 is going to be people who are truly at the top of their fields on a global scale. EB2 is going to be people who are very accomplished in their fields, but not at EB1 level. And then EB3 is a step below that where it actually can include what are called unskilled workers. So you kind of have that step down process in these. Now, one thing that's worth mentioning is there's no prohibition on applying for through more than one category. So let's say you qualify for both an EB-1A as well as an EB-2. You can file both applications. Why would you want to do that? Well, going back to the visa bulletin, sometimes it actually might be faster to apply for an EB-2 if the EB-1 is backlogged. It might be advantageous to apply for an EB-3 instead of an EB-2. So you can have two applications going at the same time, and then if a green card becomes available in one before the other, you can pursue that one. So that is one reason why people would want to apply in more than one category. But let's get into a few of the details regarding EB1, and I will quickly say we do webinars on these categories and actually have full-length webinars on each of these, EB1, EB2, the perm process, as well as EB5. So each of those is 45 minutes or an hour long. So if you do want more information on these, check out our YouTube channel where we do have those full-length webinars. For now, we really are going to be just skimming the surface. But for the EB1, you do need to be at the top of your field, and you will need to meet at least 3 of the following qualifications that you see on your screen. You'll see that several are highlighted because those tend to be the criteria that we see our clients meeting more often than others. So in your application for an EB1 1A green card, you need to include, for example, evidence that you have been asked to judge the work of others, evidence of your original scientific, scholarly, artistic, athletic, or business-related contributions. These are all pieces of evidence to show that you're at the top of your field. You can include evidence, showing that your performance of a leading or critical role in a distinguished organization, evidence that you have a relatively high salary in your field. If you have won certain awards, the award that is sometimes used as an example in this is the Nobel Prize. It's not a requirement, but it is a good example of an award that would be considered top of your field. The government is strict about that. So, if your award is a national award, even if it is the most prestigious award, say, in Germany for literature, um, we would certainly include that, but be prepared to explain why a national award does show your global prominence in your field. So you need to be ready to truly, or your attorney needs to be ready to truly advocate for you in these categories using these pieces of evidence. And again, the government lists these as examples of evidence that you can use to show that you are at the top of your field. But there is a lot of room in these applications to advocate and to really show how and make the argument for how you do qualify as being at the top of your field. One of the significant benefits of an EB1A, which is shared with the EB2 national interest waiver, which we'll talk about on the next slide, is that you can self-petition. What that means is you do not need a US employer to file the application on your behalf. That not only saves you from needing to work with a US employer and get that endorsement and that sponsorship, it also cuts a lot of time out of the process. So being able to self-petition is a huge benefit. So for entrepreneurs, the EB1A could be a good option if you qualify. It is a two-step process. Basically, the first form that would be filed is the I-140. You would send that to USCIS. Once that is approved, USCIS will consider the I-485, again, assuming that the category is current for you. And that's the two-step process. With the I-485, you can file the travel permit and the work permit applications. Switching to the EB2, EB2 has two subcategories. One is the national interest waiver, and the other is PERM. We will talk about PERM in the next slide. And what that means. Basically, PERM is when you have an employer sponsor. Right now, we're going to talk about the national interest waiver. So the EB2 national interest waiver is a wonderful option for a green card. We are quite thrilled with the EB2 NIW, and we regularly have conversations with clients who might be good fits for the EB2 NIW. And that's for a number of reasons. Basically, a few years back, the government released a decision called DANISAR, which explicitly explained how the national interest is a great fit for entrepreneurs. So again, you can apply for an EB2 NIW if you are self-employed, if you're an entrepreneur. Now, what are the requirements for that? So there are threshold requirements for any EB2 green card. The first is you do need an advanced degree or a bachelor's degree and 5 years of experience or proof of exceptional ability. So there is no way around those threshold requirements. When you see exceptional ability, keep in mind the requirements from the previous slide. They are not as strict as the evident pieces of evidence from the prior slide. You don't need to show, that you are the leader of your field on a global stage. However, you do need to show that you are of exceptional ability. So you are beyond what someone typically shows in your field. You do need to be a standout member of your profession in general for an EB2. So once you meet those threshold requirements, If you are applying for the national interest waiver, you would then need to show basically three things. The first is that you want to use the EB2 national interest waiver, the green card, to pursue a proposed endeavor that is of national importance. Now, that term national importance can be quite intimidating. It does not mean that your endeavor is going to positively benefit every single person in the United States or every single state in the United States. That is not what national importance means. It also doesn't mean that the endeavor needs to be something that is relevant to the country in terms of, say, defense or technology. What it means, though, is that you do, again, need to advocate for the importance of the endeavor. Now, if the endeavor is, say, in pursuing a certain technology that is relevant to national defense or addressing climate change or something along those lines, that's wonderful. But if your endeavor is creating jobs in a socioeconomically distressed region of the country, that could qualify for an EB2 NIW. And I like that example because it clearly is not creating jobs across the country, but it is doing something that is important for the United States generally, which is being mindful of job opportunities in rural areas, of job opportunities in areas that are struggling socioeconomically. So be aware that there is an opportunity to advocate for yourself regarding an NIW. That being said, I will just briefly say many of our clients are on E2 visas, which basically allows people of certain citizenship, people who have citizenship in certain countries, to come to the US to build businesses. And many times, people who are on E2s consider EB2 national interest waivers, and they're running businesses like a restaurant, or they're running a business that may have 5 employees, which obviously is critical to do, very important and beneficial for their community. But that alone is very likely not going to qualify for an NIW. So when I do say job creation, I am talking about a scale that is 100 plus jobs. You really do need to be able to argue that this is a significant benefit to the region. So do keep that in mind with the EB2 national interest waiver. Now, how do you show? What evidence do you include to show that your proposed endeavor is of national importance? You would include expert letters. So these are letters from people who are both experts in your field, as well as people who are members of the community who are familiar with your work and familiar with its impact. Oftentimes, mayors, governors, Congress people are good letter writers. If your endeavor is regarding research, you would want to have professors, people who are familiar with the work. You really do, again, you want to think about what is it that I'm trying to convince the government of. You are trying to convince the government that you have an idea, and that idea meets the standard of national importance. It's going to have a substantial benefit on the US and be of national importance. So who is best qualified to speak to that? That the government will listen to. The government listens to experts, authors, professors, politicians. So we work closely with our clients to figure out what letter writers should be approached, and also helping to write those letters, because they really are critical pieces of these applications. If your application is based on job creation, just as an example, you'll want to include proof that that this area is in particular need of job opportunities. So you might have a report from an economist talking about the impact of your endeavor. That is the first of 3 kind of prongs, 3 pieces of a national interest waiver application. The other 2 are that the person, being the NIW applicant, is well positioned to advance the proposed endeavor. So the first prong is about the idea itself. The second prong is about you, and saying you are the person to accomplish that proposed endeavor. So this is going to require expert letters, evidence of your personal accomplishments, showing that you really are the right person to make this happen. And the final of the three pieces of an NIW application is you need to convince the government that they should waive the labor certification process. So basically, that means that you as in your company should not need to test the US labor market, don't need to advertise the job. This prong is usually not difficult to overcome. If you satisfy the first two prongs, in particular, if you're an entrepreneur, there's language in Danisar that explicitly says entrepreneurs generally should not have to meet the labor certification process because the definition of an entrepreneur is someone who creates jobs. So they are almost by definition not someone who is competing for a job, and therefore the labor certification process is not relevant to them. So speaking of labor certification process, let's move to the next slide, which is EB2 perm and EB3 perm. So again, the difference between EB2 and EB3 largely comes down to the individual's qualifications and whether they have a degree, whether they are performing a job that requires some kind of advanced education. But the reason why both of these are on the same slide is because EB2 perm and EB3 both require testing the labor market. And that process alone can add a year plus to the application process. And of course, does require working with a US employer sponsor. So basically, what this looks like is a US employer gets your job application, decides they want to sponsor you for a green card so that you can come to the US or stay in the US to work for them. If a US employer wants to do that, they actually need to go through what is called the PERM process. So step one of the PERM process is the employer will apply to the US Department of Labor for what's called a prevailing wage. So that is the wage that you would need to be paid to do your work in that job. And this is almost always higher than a minimum wage. The Department of Labor will respond to your application and will say, here's how much you need to pay this worker. Once you have that prevailing wage, you will advertise the job. The employer will advertise the job and say, we are looking to employ someone as a computer programmer. We're going to pay them this wage. Here are the minimum requirements for the job. And it's very important that you not embellish the job description or that the employer not do that, because the government really does want to see whether there are any qualified US workers. And when they say qualified, it really is anyone who can do the job. They're not talking about a wish list. A good example of this is oftentimes if an employer wants certain language abilities, that can be a problem. The government generally does not consider language abilities to be a minimum requirement. So the employer really does need to craft a job description that has the minimum requirements, and then they post the job and they see if anyone applies. They would interview that person. And if the person is actually qualified to fill the position, the process ends. But if no one actually is suitable for the role, then the process can continue. And basically, there is a two-part process, as with the other slide I've shown. After the PERM process, the employer would file the I-140. And the I-140 is really, I should have said this before, but it really is a form that's sent to USCIS that basically says, here's who we want to employ. Here's who we are as the employer. Here's who we want to employ. And the government is saying, yes, that person and you as the employer meet the qualifications. You can now apply for a green card. And so that application for a green card is through the form I-485. So that's why we call it a two-step process. I-140 is step one, again after perm, and then the I-485 is step two. So as with any other I-485, you can apply for work authorization and travel authorization. Again, you see on the screen timing, current versus not. we've already talked about that. You can only file the I-485 if the green card is available, according to the visa bulletin. The EB-5 is kind of in a separate category in terms of the employment-based preference categories. So the EB-5, we call it a job creation green card. Many people have heard of the EB-5 because it is the golden visa. It is the investment-based option in the US. So basically, the way you apply for an EB-5 is to invest either $800,000 or $1,050,000 into a business called a new commercial enterprise. And then that business needs to create at least 10 jobs for US workers. Why two different amounts? Why 800,000? Why would anyone ever invest $1,050,000 if they can invest 800,000? The reason is $800,000, a lower investment amount, is available if the business is in what's called a targeted employment area. So those are usually areas with high unemployment or areas that are rural. And recently there was a new law, EB-5 law passed in 2022, and it created some new categories, including infrastructure projects. So if you are in one of those, what we would call carve outs, then you can invest the lower $800,000 investment amount. If instead you are starting a business in an area that is not a targeted employment area, you do need to invest that minimum $1,050,000. And those funds need to be made available for the creation of jobs. So let's say that you are looking at a regional center, and I'll talk about what that means in just a moment. But for some of these applications, there are administrative fees. You need to pay lawyers, you need to pay the regional center. That needs to be above, those fees need to be above and beyond the 800,000 or the $1,050,000. So if you're applying at a regional center, your investment is 800,000, but they charge $50,000 to administer the application, you need to invest $850,000. Okay. So the amounts you see on your screen, 800,000 and 1,050,000, that is money that needs to be available to the business, not to administrative fees. I mentioned regional centers. So we already have two subcategories under the EB-5. There's targeted employment areas and not, 800,000 and 1,050,000. But there are really two other pathways to get an EB-5. One is the regional center and the other is direct investment. So regional centers is the passive EB-5 option. A regional center is usually a very large project like a shopping mall or a resort or even a train station. Projects that cost tens or hundreds of millions of dollars that can support dozens of EB-5 investors. And those EB-5 investors are going to basically have no active role in the project. You invest your money, you don't get to decide, the color of the resort. You don't get to decide the paint color. You basically invest your money and you are a passive investor. That is the regional center option. Very convenient if you don't want to be actively involved, want to basically not think much about the application process. Regional centers are almost always created in targeted employment areas. So regional centers, you would almost always have an $800,000 investment amount. In contrast, the direct investment option is if you really want to manage the business. So to take an example, let's say you have a successful restaurant and you want to apply for an EB-5 based on that restaurant. You could do that if you invest either 800,000 or 1,050,000 into the restaurant, and then that investment leads to the creation of 10 jobs. Direct investment does require active participation in the business, and for that reason does tend to be significantly more work for the applicant. But if you're committed to your business and you want to be actively running it, it can be a great option. The other thing to know about direct investment is each direct investment business can only support one EB-5 applicant. So there's confusion around that because that requirement changed in 2022. Before 2022, you could have a restaurant with two owners, and each of them invest the money. You create 20 jobs, um, and they apply for a green card. That cannot happen anymore. If you have a restaurant, it can only support one EB5 investor. Only regional centers can support more than one, excuse me, EB5 investor. So, what investment can be included? This is typically the most challenging part of an EB5, which is proving where those $800,000 or $1,050,000 came from. The government, USCIS, is going to do a financial audit, and they tend to want to see where every single dollar invested in the business came from. So be ready to maintain very good documents of all bank records, transfer receipts. If you got the money from selling an apartment, keep all of the documents. If they're not in English, have them translated. You really are going to need to document every step of the process of the money from its origination to being invested in the business. Now, that being said, generally speaking, the sources can be quite broad. So loans that are secured by your personal assets are okay. It can be a gift as long as you can document where the person who gave the gift got the money from. So as long as the source is lawful and can be documented and is not secured by the assets of the EB5 business, generally speaking, the investment will be accepted. You just need to be able to document it. One other source of investment, source of funds that is not accepted is retained earnings. So these do need to be your personal funds that you're investing in the business. So let's take our E2 example. If you have an E2, you're running a successful restaurant and your restaurant has $1 million in retained earnings, and you say, I want to just use those retained earnings to apply for an EB5, you do need to distribute those earnings to yourself first, pay taxes on them, and then reinvest them into the business. So they have to pass through your personal account to show that they are your personal funds. Differences between E2 and EB5, there are many. They're completely different. E2 is a non-immigrant visa, does not lead to a green card. EB5 is a green card. E2 does not have a minimum investment requirement as long as you're investing enough to make the business operational. Generally speaking, you are okay. You may need to invest a little more if the business doesn't need a lot of money, but in general, an investment amount of $100,000 or even a little bit less can be fine for an E2. For an EB5, again, minimum of 800,000. So many differences. Also employment, E2, you're usually fine if within 5 years you can show you've created 3 full-time equivalent jobs for US workers. The EB5 strict requirement of at least 10 jobs for US workers, and those need to be citizens or green card holders in the EB5. And there is some flexibility in terms of time. Those jobs don't need to be created until typically 2 to 3 years after the I-526, the initial step of the application is filed. So you do generally have some time to create those jobs. I already talked about the challenges for the EB5. The biggest one is going to be the source of funds. Job creation. So I mentioned you don't need to create those jobs for a few years. So in the initial application, how do you convince the government that you're going to create those jobs? The answer is a business plan. So if you have not already created the jobs through your investment, you will need a very good business plan. We do prepare those for our clients. And the government actually through prior cases has made it clear what those business plans need to include. The EB5 filing is more generally, it has more steps than the other options we've talked about. So there are 3 steps to the EB5. The first is you file the I-526, which is basically showing that you qualify. You meet kind of just on a superficial level that you've invested the money, that you have a good plan for hiring 10 workers, at least 10 workers, and who you are and why you qualify. Once the I-526 is approved, the government will decide the I-485, which is again is the green card application. In EB5, you get a conditional green card. You do not get a, green card without restrictions. The conditional green card is good for 2 years. At the end of that 2 year period, you need to apply to remove the conditions. And that's where the I-829 comes in. That's a form that allows you to apply to remove the conditions. And at that stage, you're going to show you've maintained your investment of 800,000 or $1,050,000, and you've created those required jobs. So there are multiple touch points where the government is going to basically be looking at the business and seeing that it qualifies. So the I-526 and the I-829 are going to be those main two touch points. But once your I-829 is approved, you do get your unrestricted green card. You can then have the full rights that come with that and begin planning for naturalization if that's something that you choose to do. Other green card options. So diversity lottery. So basically these options are outside of the family-based and the employment-based buckets that I broke down at the beginning. So the options available are the diversity visa, which is kind of a bizarre but a wonderful thing that's still available, where you can basically apply. It's exactly what it sounds like. You apply for a lottery, and it's available to individuals from certain countries. There's no downside really to applying for it. If you're chosen, wonderful. You can apply for a green card, and if you're not, you can apply for the following year. There are also humanitarian-based green cards, as well as green cards based on special circumstances. And so, excuse me, asylum could be one of these. If you're granted asylum, you can apply for a green card after being granted asylum, after a certain period of time has passed. If you assist law enforcement with prosecuting a crime, or you are able and willing to do so, you may qualify for a green card based on that. Similar to trafficking, if you have knowledge or if you are a victim of trafficking, including labor trafficking, you may qualify for a green card based on that. And finally, immigration reform. There's a lot to be said here, a ton of uncertainty after the recent election. We may be seeing we almost certainly will be seeing significant changes in immigration. Whether that is in the form of a new immigration law remains to be seen. But it looks like the stars are aligned for that to happen, for better or for worse. So definitely something to stay posted on, because there could be very significant changes in the future. And finally, other considerations. I mentioned earlier timing considerations. You do want to keep in mind that, when it comes to timing, the visa bulletin is going to be by and large the main thing. When is a green card likely to be available to me based on what I'm applying for and how I qualify for it, whether that's through a brother or sister or through my spouse or through an employer. So get a sense through the visa bulletin of how long it's likely to take, and if you should begin exploring alternative options if it's going to take a while. Timing, also keep in mind, USCIS takes a while. Even if the green card is currently available, USCIS can take a year or longer to even just decide your application. So if you're in the US, you need to make plans for and have a visa. You need to make plans for how you're going to use that visa while the green card is pending. And that can be tricky because each time you're entering the US on a non-immigrant visa, once you've filed a green card application, there's an opportunity for the government official to say, I think you're going to stay, and I'm going to deny you entry on your TN or on your student visa. So you do need to be mindful of that. That's an area where a lawyer, a qualified immigration lawyer, really can help you navigate that process. Travel considerations and visa expiration dates. I've already touched on this with what I just said, but just be mindful of when your visa expires. A visa gives you the ability to seek entry into the US. That's really all it is. Once you're in the US, your I-94 controls. So we always say, whenever you enter the US, go online, pull up your I-94, make sure you know what your status is, that your status is right, and then when you need to leave the country by, so your expiration date on your I-94. Dual and content considerations. I also already talked about this. Again, dual intent is where a non-immigrant visa, you cannot intend to adjust status on that visit. So, if you file a green card, it suggests you do want to stay in the US. You need to be careful of that if you're in that situation. Parallel green card strategies. This is referring to what I said, where you can apply for two green cards at the same time, or apply for a green card based on two preference categories at the same time. So, if you have a great example would be if you are, a national of Canada or wherever, and you're applying based on a US citizen brother or sister, and you're looking at those 15-year delays, you might try to form a relationship with a US employer and start an employment-based green card application that hopefully will be decided quicker than that sibling application. Or if you come to the US and fall in love with a US citizen, well, you can go ahead and file that immediate relative green card application, and you're going to be in the fastest pathway. And again, planning is key. So this has been kind of a theme throughout the presentation, but it really does generally benefit someone to meet with a qualified immigration lawyer before you've taken concrete steps to map out what your goal is, as well as how best to get there. And we are very happy to help with that. I would just say, if you do want to continue the conversation, please do visit our website, schedule a consultation. We'd be very happy to talk with you. And with that, I didn't see any questions come in. We do have just a few minutes left. So for any last moment questions, feel free to send them my way. But otherwise, please do check out our YouTube channel. We're very proud to put high quality information on our channel for free and to make it available to all of you. So we do hope that's helpful. Do sign up for future webinars. We love giving these presentations and answering any questions you have. Check out our website. And if you do have questions about your specific circumstances, schedule a consultation. You have the option through our website to find a time that works well for you, to reserve either 30 minutes or an hour. We are always happy to talk. With that, we do hope to see you on future webinars. Jelena, thank you. And everyone, stay safe, stay well. We hope to see you very soon. Bye-bye.